And before we go any further, ladies and gentlemen, we would like to extend a word of gratitude towards all our sponsors and partners for their support, their encouragement, and for their contributions towards making the 16th edition of the Mindmine Summit possible. Can we have a big round of applause for all our partners and sponsors, please? Thank you. And with that, it's time for us to turn our attention to another question that has profound implications on India's growth story. Now, a strong economy needs institutions. Few are as important as the justice system of the economy itself. So in our next session, ladies and gentlemen, we ask the question, justice in slow motion, how can India's courts catch up? And what a lineup we have to take this session ahead. Ladies and gentlemen, let's hear it up for one of India's most respected legal professionals who brings extensive expertise across corporate law, dispute resolution and regulatory matters. Let's put our hands together for Managing Partner Shardul Amarchand Mangaldas, Ms. Pallavi Shroff. A big thank you, Ms. Shroff, for joining us this afternoon. Joining her on the panel is the co-founder and managing partner of AZB Partners, Mr. Ajay Bahl, a leading legal expert who brings deep experience in corporate law, governance, complex business advisory, Mr. Ajay Bahl. Honored to have amongst us for this panel Member of Parliament, Ms. Bansuri Swaraj, a strong voice in public life and law, bringing a valuable perspective on governance, policy and justice system to this panel. A very warm welcome to you, ma'am. And to masterfully steer this conversation ahead, ladies and gentlemen, let's welcome our moderator for the session, Editorial Director of Business Standard, Mr. A.K. Bhattacharya. A very warm welcome, everyone. Over to you, Mr. Bhattacharya.
Thank you. Thank you very much. Very good afternoon. It's a privilege and honor to be moderating a discussion with three eminent persons. Each of them has distinguished himself in our field, and the subject is equally exciting. And the subject, I don't want to introduce my fellow panelists here because they're all known. You have Bansuri Swaraj, who is a member of parliament. You have got Ajay Bahl, who is managing partner of AZB Partners. And you have got Pallavi Shroff, who is also managing partner of Amarchand Mangaldas. Now, the subject that we're going to discuss, and we're going to discuss this, this is not a session where people listen to speeches. People come here to interact and discuss, and then maybe in the last 10-15 minutes, we would like to have some session questions, responses from you, so that we come to a kind of a broad understanding of the issues that we are raising. And the issue that we are raising is very simple. It is staring us in the eye, which is the pending cases in India's courts. What is their number? We all know. 5.5 crore cases are pending in India's courts. What is the cost? The cost is huge. By one estimate, that cost is 1.5 or to 2.5% of India's GDP. What does it mean in real terms? It essentially means that it's almost 5 lakh crore or 9 lakh crore of money going down the drain because of stuck court cases. What do we lose? We lose productivity. We trap our capital in these cases, and as the cost of capital goes up, the legal enforceability and that reputation, the perception, that takes a hit. Then there is also a social cost. Social cost is because if you look at these stuck cases, the people, according to one study, people who are earning an income of less than 1 lakh, their additional cost because of the stuck cases in the courts is 10% of their income. Whereas those who are earning more than 1 lakh, it is 3 to 5%. So clearly, it is actually driving a bigger and wider wedge into income inequality. So people who are low down the stratum, they are suffering more, and people higher up in the spectrum, they are suffering, but they're suffering a little less compared to their overall income. How do we solve this problem? So our central point here is that how can India's courts can move from this awareness? I think we have seen the courts have this awareness of this stuck number of cases to action fast, and what will it take for us to get to that desired state of goal? What we'll do is that we will like to discuss 4 broad issues to understand this. There is obviously, we need to understand what will it require to reduce the backlog of cases. We need to discuss the resultant consequences, which is that the large number of prison inmates because of these court cases, which is another element of why these court cases are there. Then there is, of course, as I mentioned, that the people lower down the stratum, they also suffer. And finally is that how can we improve the certainty in businesses? Because if a foreign investor or an Indian investor realizes that justice will be delayed and therefore justice will be denied, so why should I invest in the money? Rather, I go abroad. Or a foreign investor will worry that why is the enforceability of a contract is subject to delays in court, then why should I invest here? So there's a host of issues there. So what we'll do is this, we'll start our discussion with our speakers here. And let me begin with the youngest of them all, Bansuri. What I will like to ask you is this, what does it really take, in your view, to reduce this long wait list? In what way can we actually declog our courts? Give us 1 or 2 solutions.
So first of all, thank you very much, Mr. Bhattacharya, for having me here. And it's such an honor and a privilege to be amongst you, especially to be part of such an august panel. There are certain people here, I think both of you have literally grown up watching the two of you. I've had a very interesting relationship with adjournments. When I was a junior at the bar, I used to dread them because if you failed to get one, it meant that you would be reprimanded by your senior. When I got designated as a senior counsel, I loved them because it meant per peshi ki fees aa rahi hai, to ek aur peshi lagti thi. But now that I am a parliamentarian, I'll tell you, I really realize the social cost, the cost to the country as well. And this is a very, very, I would say, it's a plague that is infested our judicial system. And surprisingly, even though I'm a member of parliament, my solution is not legislation driven. My solution is actually implementation driven. And it's very easy. if you actually leverage technology. I'll just give you two examples. First, I think that VC hearings should be the norm and not the exception. COVID was a blessing in disguise for the litigation profession in India. It actually ensured that the dropout rate of female lawyers dropped because they could actually access courts and they could sort of conduct hearings from the comfort of their homes while taking care of their families or whatever other requirements they had. So VC hearings will definitely expedite the number of cases that you can dispose of. The second aspect that I would want is to leverage technology like artificial intelligence, because what's happening is a lot of the judicial time and the taxpayers' money is going not in adjudicating the matter. What happens is that the judges end up wasting a lot of their time in the procedural aspects, in case management hearings, and all of that can actually be delegated to artificial intelligence. I'll give you, you were talking about under trial prisoners. I would just like to actually give you a very easy solution. So we all know that section 479 of the BNSS actually entitles bail to an under trial prisoner after 1/3 for first time offenders and if 1/2 of the maximum sentence has already undergone. As of August 2024, the Honorable Supreme Court of India made sure that this provision started having retrospective effect. You will be shocked that hardly any of the states have implemented it. It's really easy if you end up having a dedicated virtual hearing court only for bail matters in such cases. And second, if let's say we actually had a system where we could leverage AI for generation of simple bail applications in such cases, because here you just have to see what is the undergone period, whether there were some certain criminal antecedents or not. If you have a performer, then you are making sure that the drudgery of drafting and sort of doing the research associate work is given to AI, and this is done without compromising the judicial discretion.
Excellent. I think I've understood your point, and point very well made, but just wanted to sort of draw your attention to the fact that Supreme Court already has introduced AI in a certain way. You have got SUPACE, you have got SUVAD.
Yeah, but so I'm talking about trial courts.
You're talking about trial courts.
I'm talking about trial courts because I'll tell you, see, that is the first frontier for under trial prisoners. Supreme Court is the last bastion.
So you want that to be done in a trial court?
I want VC hearings to become the norm for trial courts. I want technology to be leveraged at the trial court level. Because a lot of trial court time in litigation is unfortunately wasted on procedural drudgery.
That's wonderful. So I think I'll come to Ajay. What's your medicine for this problem that is confronting us?
So one is the first thing which I saw, which was the distinction. You're still seeing the eyes of justice only from the eyes of the Supreme Court and how the Supreme Court performs. That's not where justice is. Justice is starting from the ground level.
Fair enough.
That's really, I think, one of the things that is very important to note, which we lose sight of. So when we talk about 5 crore cases, of them 4 crores are at the district courts.
Yeah.
3.7 crores of criminal cases and about 20 lakh civil cases. Personally, I think over the years, we have spent too much time. Maybe I'll first talk about a little bit of economic equivalent. There is demand and supply. So I am treating supply as being our infrastructure, our courts, our judges, technology, all the good things that you want to do. And demand is the pipeline for cases. We have actually, if you look back over the years, in fact, there'll be no emphasis at all on trying to deal with limiting the demand for cases. That is your biggest problem today. Your criminal cases are growing by about 20 lakhs a year. Almost every court, the institutions annually are greater than the disposal. So the question of dealing with old cases is becoming extremely difficult. So the supply side will continue. We have to do what we have to do. The demand has to be addressed. How do you address the demand? That means you reduce the pipeline of cases. So one example was the decriminalization we did, right? The decriminalization that we started, which started only a few years ago. But also just coming back to this issue, and I'll give you a few more examples of that.
Sure.
Secondly, we have to start looking at courts beyond courts. We have to look at courts, and I mentioned this to Sunil, and he was because he's a commercial person. I said most of our commercial decisions today are taken by tribunals. Your NCLT is got everything that was earlier done by courts on disputes and so on and so forth has moved to NCLT. They look at insolvency cases. You've got income tax tribunals. Traditionally, when you look at we have a judicial grid, very nice judicial grid, which gives you the pendency of cases. No tribunal data is on that grid. And I'm happy to say that based on the efforts, Sunil, that we all made at CII, MCA has taken the initiative, and the NCLT data and NCLT data will still be hosted on the judicial grid. So you get to know what the pendency is across all of these tribunals. So once you know all of that, then you focus on your attention on the reduction in the pipeline. So decriminalization, applying that to pending cases. We have had 2 JV1s, Jai Vishwas, but unfortunately we denied access of that to pending cases. The whole purpose of declogging goes away. And then we can discuss it a little in detail, but you have to give more and more settlement mechanisms, like you have for SEBI. SEBI has very effectively done a settlement mechanism where you can settle without admission of guilt. So bring in settlements. The other area that needs to be addressed is the limitation. Today, for every offense where the punishment is more than 3 years, there is no limitation on filing. This limitation was introduced, believe it or not, in 1971, where for the first time a limitation of up to 3 years was introduced, and it was said that we will look at limitation for beyond 3 years later. Now, 45 years have gone by. We have not looked at a limitation for those cases where the punishment is more than 3 years. And many of them are constantly misused with a view to file cases which are belated, which are come into the system and then clog the system as well. So I think I would focus more on the demand issue while we continue to do all the stuff that we have to do on supply, like judges, infrastructure, AI, etc.
So decriminalization, settlement, and limitation. The broad issues. Yeah. Excellent.
Focus on reducing the pipeline of cases
Pipeline
as
of
well.
this thing. Pallavi, your take on how to address this menace?
Reasons for this humongous backlog are many. So therefore, just 1 or 2 solutions will not solve the problem. We need a multi-pronged approach. We need a very serious approach, a dedicated approach, and a long-drawn, a committed approach to resolving this. We do it today, we don't do it next year, we do it the 3rd year, that's not going to work. And I think what Bansuri said about it being an implementation problem is really the real crux of it. For example, when you talk of the reducing the pipeline of cases, government had the national litigation policy. The largest litigant in the country is the government. Can anybody in the government today take a call not to move if they've lost a matter, that they will not file an appeal? They will not go all the way up to the Supreme Court? No, because if some officer decides not to appeal, 10 years later, there will be a CVC inquiry against him. There will be a CBI inquiry against him.
Absolutely.
So they keep filing till every remedy is exhausted. That clogs up all the courts. 60 to 70% of the litigation is just Can we ensure and can we do something to ensure that government is stopped from filing these litigation? Can the departments, for example, have a committee that reviews every matter where an appeal needs to be filed? No individual will take, but if a committee were to take, or a group of people headed by a lawyer or a retired judge or something, and there are plenty of retired judges in India,
Okay.
somebody who can sit there, review the case and give an opinion saying, don't file, it's meaningless filing this. But nobody does this. Are there other settlement mechanisms and parameters within which the department can settle a dispute? Why must you go into an arbitration and litigation? There are no such mechanisms which we can do it. There was something years ago where 2 departments, if they were fighting, or 2 ministries, you could go into the cabinet secretariat and they would help to resolve. But even that has been abandoned now. So if you start developing some such mechanisms, I think that would go a long way in trying to reduce the pipeline on the demand side. If you come to the supply side, number of shortages of judges. We have 22 judges per million. Ideal situation is 50 plus judges per million. We are grossly short of the number of people who can adjudicate a dispute. So, how can we increase the number of judges? Even if you can't increase the number of judges, what about just filling up vacancies that exist today? Vacancies are just not filled for years. The PMLA Appellate Tribunal, the FEMA Appellate Tribunal, wasn't even constituted for about 3-4 years. We all ran to the High Court over every matter. So these sort of delays actually clog the courts instead of going there. I think that is the other thing. Now we talk of filling up vacancies and everything, but where is the infrastructure for all these people to even act efficiently? I think Bansuri has so correctly said we need technology. Where is Wi-Fi? Where are the computers? Where are the trained people, court people who can manage the court as such? We don't have that. Come to the lower courts. You come to Tis Hazari court, in the same courtroom, the judge is taking evidence, the reader is taking one evidence, and somebody else is doing an evidence in the other side. 3 people doing 3 different matters. There's no infrastructure. The judge has no chamber to sit in. So, if we don't want to spend money on the judicial system, what do we expect? We treat this as also some amount we've spent. Government can't think this is too generous.
Well, Pallavi, I think there's a. Sorry, you wanted to say something more?
No, I was also thinking one of the most successful mechanisms of reducing the cases has been the Lok Adalats. How can we use that more, perhaps, is what I would think.
Okay. I think the common theme in what you said is the government. I mean, government must reduce litigation. The government must make sure that it facilitates the appointment of more judges, and the government should set up more Lok Adalats. So you are pushing the ball in the government's court. Unfortunately, we don't have anybody here from the government, but maybe I will turn to you, Bansuri. I'll turn to you, but before that, let me ask you, Pallavi, a counter question to your point on judges. Do you think one of the reasons why you are having so many vacancies, apart from many other reasons, is that our compensation mechanism is not good enough to get enough number of people from, advocates like Bansuri to consider be a judge? Is that an issue?
Partly. I would think partly, not entirely. Because there are many people who would happily want to be judges. Well, the judge doesn't get a fat salary if you look at it, what you would get as a successful lawyer. But there are other benefits and privileges that a judge gets that I think compensates. I've seen that for myself. I come from a family of judges, so I've seen that. But I don't think that is the real issue. There are many other reasons because you get you can't, if you're in a high court, you can't come back to the same high court and practice. You can only practice in the Supreme Court. There are other restrictions that people don't want to go into the judiciary. The second, I think, bigger issue is it's not only about the government. Government could be one issue. I think as litigants and as lawyers and people who advise corporates, I think today, if you ask me, litigation has become part of corporate strategy. How can I litigate and get an advantage or prevent my competitor for the next 6 months, 8 months? So that's become part of a strategy. That is very difficult to do away with as, business grows, economy grows. And the judges who have to come in also need to be trained in business and commerce.
Absolutely. Bansuri, the ball is in the government's court. Ajay has talked about decriminalization, also settlement, government becoming a litigant, civil services reform a little bit because, so how do you address those issues in the government system?
I think it's a fair point which has been made here, to very realistically. But
So the government is actually moving in that direction. The Jan Vishwas bill, which has recently been passed by Parliament, is basically working across, I think, over 183 provisions across various statutes is being decriminalized. So the government is working towards that. As far as judicial appointments are concerned, I take your point on that. But having said that, you also know that appointment of a judge is not an easy task. There has to be a 360 IB inquiry. There have to, it's a tough life to be a judge. It requires a lot of isolation. It requires a lot of building of Chinese walls around you. And it's a different ask. It's a different kind of ask. What I would concentrate, because we need an immediate solution. And I think the immediate solution should be about augmenting the existing capacity that we have. And that is very easy. So you were asking for solutions. I actually came with one more. For example, we can extend the Commercial Courts Act 2015's case management model to all civil suits above a certain value, and we can have a value threshold for it. Basically, a mandatory case management hearing within, I would say, about 30 days, and with fixed timelines for pleadings. What's happened is that the criminal statute has already been amended, but the CPC is still very, very procedurally heavy. I think that also needs to be sort of diluted a bit and simplified. But one more thing, which is not, I think, government-oriented, but citizen-oriented approach is something that we need. We need to have cases happening in the local language. Half of the litigants don't understand what's going on. I mean, I remember being in college 21 years ago in Britain, and the Wolf reforms there did away with Latin. And here we are still quoting Latin maxims. There are people who don't understand English and really depend on their, or a junior in the chamber, sort of giving them a sketchy briefing of what happened in court. We need to make it, and we can, again, as Pallavi ji said, we need to leverage technology. With the help of artificial intelligence, you should be able to generate a brief summary of the court judgment or the order in the local language, so that, especially you were talking about Supreme Court, we have litigants coming from all across India. If you speak Tamil, if you speak Bengali, it should be a matter of minutes where you should have a summary of what exactly happened in court that day. And VC hearings in Supreme Court has really helped democratize the entire procedure, because now you know that the litigant is sitting somewhere in Tinsukia and is able to see whether the lawyer actually reached for the hearing or not.
That's right.
And I think, again, the answer is to augment the existing capacity.
Absolutely. You want to say something? Yeah, sure.
Existing augmenting capacity is very, very important, and I agree with you. As you said, this is more on implementation rather than new stuff. Existing judges can be done. There can be so much of training of the existing judges. For example, CPC is amended to say no more than 3 adjournments for putting a written statement. Nobody implements it. Every time there is an extension, some nominal costs are imposed, and we get extensions after extension. If we were to impose that, it would be fantastic.
I think that's
Ajay,
the
would
point.
you like to?
See, when you speak to the government on the same issue, I had a conversation with the government. They said, you want us to stop litigating, and you want us to agree that at a certain level we will not file appeals. Are you willing to agree that your private clients will do the same?
Who in the government were you speaking to?
No, so that apart. No, I mean, there are people who are looking at this option, but they ask this question: will your clients agree to do the same? So that's also an issue, that we are seasoned litigants. We fight about everything. I think that the issue is that, it's having judges appointed. I'm not, obviously, as I said, that the supply side has to be augmented, but it's not easy. Judges are perishable. People will pass away. You'll have to keep finding judges. I think it has to be a pincer attack from all of it. At the end of the day, unless you reduce this pressure on them, and which is not difficult to do, and that's purely in the hands of the government. I'm saying this because then you don't need the judiciary, you don't need the lawyers. We are as responsible. We all have our limitations, but at least bring in an external element into the equation. Let me give you an example on impact analysis, why I brought up the judicial grid.
Sure.
See, one of the biggest challenges today is how do you judge the impact? Even if we talk about the Jan Vishwas bill, how do you judge the impact of a decriminalization of a particular provision. If you look at our judicial grid, it's very good. It gives you the kind of cases there are, but it does not granular detail of what case, under which section, how it has been filed. When I raised this issue with Ministry of Law, it's very interesting. They said the fields are in the data. The fields are not filled up at the court level. So when you look at impact analysis, that is the most starting point. That if I have granular data in India, we have manpower, we have the technology. If we were to first upgrade our judicial grid, then you know that if I was to change this particular provision, this is the number of cases that would go away. Even with Jan Vishwas, as I said,
That's right.
there's a specific bar to retrospective application, which we had suggested should not be the case. When we amended the Companies Act, we gave the benefit to old cases. The law is very clear. But I think if the more we work on both fronts, I'm not suggesting that, this is the only solution at the supply
Absolutely.
side, but unless we arrest that, because you ask yourself the question, we took cases out of the High Court to the tribunals.
Yeah.
That should have freed up, logically, that should have freed up the High Courts, but it hasn't. They have blocked, the side roads are blocked. So wo jam वैसे का वैसा ही है, tribunal में भी.
That's right.
So everywhere the impact analysis, was there ever an impact analysis done कि NCLT के आने से did things really improve? Never.
Well, NCLT case was the problem because NCLT was already set up and you dumped on it IBC cases. So NCLT, which is already overburdened, became even more overburdened.
Right, exactly.
Competition
But there was no
law,
impact analysis.
Competition law,
That's why I said there was no impact
There's
analysis
no impact
because you
analysis.
threw all of those.
Absolutely.
And insolvency cases, all our winding up cases
Yeah.
became insolvency cases. So we would have mergers pending and our hearing would be after somebody who's filed a case for some 50,000 rupee debt, 5 hours that's going on, and our merger client is sitting back and saying, when is my merger hearing going to happen?
Okay. There is a clock that is in front of me which says only 6 minutes left. I would like to take 2 questions from the floor. If you have any questions to this wonderful panel here, is there a mic there? Is any questions? Yeah, please go ahead. Please identify yourself. And if your question is to a particular person, please name that person. Be brief, and it should be a question or a quick observation.
Good afternoon, everyone. I'm Prakhar Deep. I'm a lawyer based in Delhi. My question is to Ms. Bansuri Swaraj. As a lawyer and as a lawmaker, we all talk about delays in judicial adjudication, but enforcement of decrees is a very big problem in India. Do you think, and I want to run this to you as a parliamentarian to have a think of it, that enforcement should be taken away from courts and you should maybe have an agency or a department that can look into it, because courts are already burdened, but forcing a litigant to wait for fruits of the decree is something which can be taken care by someone else. So your thoughts on it?
Bansuri.
I completely agree with you. And whenever I have had a chance to sort of, discuss this or escalate these kinds of concerns, that is the first thing that we have said, that you need to actually sort of ensure that you separate these two, because otherwise this is an aspect which is misused as well. The delay gets weaponized. Somebody will win the case, and in order to, the decree is there in their hands, but then, like I said, the opposite party can be very unscrupulous and they can weaponize the delay. And this is a concern that we have been sort of discussing where we need to.
Would you like to add to this?
I think I would add one thing, Prakhar. Just what they've done in the Arbitration Act, and they've amended that if you get an award, if it's a money award, normally under Section 34, when it got challenged, you got an automatic stay. That provision was removed. And provisions of Order 41 came into something like that. We need to think a little more creatively so that it doesn't come as an automatic stay. The courts react faster, even if it has to be a court, or it's a separate execution court, a earmark for execution. Something needs to come more creatively and as a reform within the existing court system. Can you earmark 2 judges who are going to only enforce the execution of decrees or awards or something like that?
Ajay, would you like to respond, add to this?
I mean, that's a part and parcel of the whole delay. I mean, at the end of the day, you can't set. Once there is a delay in the whole system is going to get clogged.
Absolutely.
So the problem is when you say better cases should get off better, higher value cases decrease, it's all going to suffer.
Yeah.
But our procedure under CPC for executing a decree is just so long.
That's right.
It's just so long. Order 21 just goes on and on.
Yeah,
Till
yeah,
100.
yeah. So there's a question
Order
from there.
21 rule, 100
Let's
will
take
come.
this question from there. Yeah. Yeah.
Thank you.
Yeah.
Hi, I'm Chahat Agarwal from AZB Capital. My question is open to the panel. Anyone can answer that. We talked a lot about AI implementation in justice system. While that's a solution, but that there has to be a difference between a change for the sake of change and a solution that adds value and solves problem that is the basic core, right? Not just capacity building or the surface level. So when we talk about technology implementation, the most common problem is the data leaks, cybersecurity, and also, as we know very popularly, which is how AI reads documents and interpret data, so on and so forth. So how is your plan to move forward when we talk about AI implementation needs to be actually executed in justice system?
Okay, Bansuri, you start and then we'll move this way.
So with AI, it's easier to train an artificial intelligence model than it is to train a large number of judges. And I think the first thing that you can do is ensure, because AI is governed, or sort of the reference point will be the kind of data sets that it is going to be trained on. So I would first of all advocate for indigenously developed AI. So basically AI which has been developed by India, which is stored on Indian data servers. And of course, we had that AI summit in New Delhi. I know that the foundation has already been laid for this. The second thing I would do is I would definitely train it on India data sets. And the third thing is that when you're training it, I would make sure that it is trained on all Indian languages, all recognized Indian languages.
That's right.
So
Ajay?
just to add to what
Sure.
Bansuri has said, the Supreme Court has already used domestically developed AI in several programs. I think it's still little early stages. Yeah, it's not gone really used and gone too deep into it, but it's got Supace, Suvas. Then there is an AI, Just Is mobile app. They've got a case management and a filing system, AI Saranch, which gives you the summaries. There are a number of software AI developed and developed locally in India for the court. And they also have an automatic translation. The Supreme Court judgments have some 40,000 judgments have been translated in almost all the official languages. Yeah, this has to start it here, but it has to just...
What about the guardrails? Are there enough guardrails on this technology? I mean, you don't want a situation where somebody's life or death depends on their judgment, and the judgment is created
What's happened
by...
in the US,
You need robust systems at the end of the
So
day.
I'm saying I think we also need guardrails for execution of an AI thing.
There's no
What do you think?
accountability. That's the problem with AI.
Accountability.
There's no accountability.
No, I would differ with there. I would say that I'm talking about implementation of technology without taking away the judicial discretion.
Absolutely.
The decision-making power always remains with human beings, because equity is part of law. And an AI model would never have that.
Okay.
That kind of empathy,
Wonderful.
humanity is necessary.
No, that can never be substituted.
Ajay, you have the last word.
It has to be an aid. If they take over human brains and human mind, then we are in deep trouble.
Okay. Okay.
I don't think
What?
AI will ever substitute, at least not for the time being, substitute the human brain or the ability of a judge to take that decision. It should not.
Okay. On that optimistic note, let's close this discussion. I think we had a wonderful charged discussion on the question of court cases, clogging the courts and delivery of justice. We had many solutions that were offered by the panelists here. Mostly it seems to me that government has a lot to do And I hope somebody from the government will listen to this discussion and take necessary steps in good time before it becomes a bigger challenge. Thank you very much to my panelists for being here, taking part in it, and thank you, the audience, for listening to us and asking very good questions. Thank you.
A big thank you to all the panelists for such an insightful discussion. I request all of you to please get together for a group photograph. Thank you, Mr. Bhattacharya, Ms. Swaraj, Mr. Bahl, and Ms. Shroff for sharing your perspectives on one of the most critical pillars in Indian democracy and development, that is the justice system. I request Ms. Shefali Munjal and Ms. Geeta Anand to please join us on stage to felicitate our presenters with a small token of appreciation from our side. Thank you, Ms. Munjal and Ms. Anand, for doing the honors. Ladies and gentlemen, let's see them off with a big round of applause, please. Thank you once again. And with that, ladies and gentlemen, it's time to refuel, but we have a strict 15 minutes coffee break lined up ahead. So please feel free to connect, but be back because we get into a very important session exploring how the energy landscape in India is evolving going ahead. Thank you, and we'll see you in 15 minutes.